So last week, in a stunning move, Acting Attorney General Todd Blanche announced that medical marijuana has been officially rescheduled to Schedule 3. It's a monumental change in federal cannabis policy that had stood in place for over 50 years by moving medical marijuana from Schedule 1 to Schedule 3.
While President Trump issued an executive order back in December 2025 to order the federal government to reschedule marijuana to Schedule 3, news on that front had been quiet until last week's groundbreaking announcement.
Welcome to A Higher Law, a cannabis podcast from the Dykema Law Firm. My name's Lance Baldry. I'm a member at Dykema and national leader of the firm's cannabis group.
And I'm John Frazier, member at Dykema and Michigan team leader of the firm's cannabis industry group. On today's episode, we break down last week's historic medical marijuana rescheduling order, and we look ahead to the rescheduling process for adult use cannabis. Lance, can you briefly just walk us through what happened last week?
Well, I don't know if there's anything going to be too brief about it. There is, I think, enough for us to talk about on rescheduling for a handful of podcasts. But let's cover the critical points today. Under the Controlled Substances Act, the Attorney General has the power to issue an order to control a drug under the schedule that he deems most appropriate to carry out the U.S.'s treaty obligations under the Single Convention on Narcotic Drugs. Last week, the AG exercised that power to issue an immediately effective order that reschedules FDA-approved and state-licensed medical marijuana to Schedule 3, and also immediately amends the DEA's federal regulations by adding numerous marijuana-specific requirements. John, you want to talk a little bit about why this is so important?
Yes. I mean, this is really probably for most people in the country the single biggest shift in federal marijuana policy in their lifetime. Marijuana was scheduled in Schedule 1 back in 1970 when the Controlled Substances Act was initially adopted. And there's plenty of historical evidence and evidence in the congressional record that supported that marijuana be scheduled in a category something other than Schedule 1, which is the most restrictive category. Nevertheless, marijuana wound up as a Schedule 1 substance, largely for political purposes as opposed to any sort of scientific or public health purposes. And marijuana has remained in Schedule 1 despite the fact that there's now pretty overwhelming evidence that marijuana has therapeutic health properties and does not belong in Schedule 1, where kind of the most restrictive, most abusive types of drugs have been. So notwithstanding the fact that the science hasn't supported the scheduling, it's been an issue of political will largely that's kept marijuana stuck in Schedule 1. And 56 years of federal marijuana policy were now seemingly just reversed with the stroke of a pen when Acting Attorney General Todd Blanche fundamentally altered the federal government's official policy with respect to marijuana by ordering the immediate rescheduling of medical marijuana.
Well, John, he says he did this under the Single Convention on Narcotic Drugs, which is the international treaty that the United States is a signatory to, as are most countries, and requires scheduling and specific controls for different types of drugs. And indeed, it's got some requirements that are specific and applicable to marijuana. What are those? And I'm curious sort of how did the Attorney General decide that all of a sudden those requirements that we've not been able to satisfy before apparently can all of a sudden be satisfied?
That's a great question. So, I think we need to take a little bit of a step back too, right? So folks will remember during the Biden administration, President Biden directed the then Secretary of Health and Human Services to conduct a study as to whether or not marijuana should be rescheduled. And as part of that study, too, the Office of Legal Counsel at the Department of Justice authored a memorandum in 2024 that concluded that rescheduling marijuana to Schedule 3 would be consistent with the United States' treaty obligations. And so Acting Attorney General Todd Blanche now in the Trump administration has largely relied on that 2024 legal memo that started the rulemaking process to reschedule to Schedule 3 under the Biden administration. And so some of these requirements in the UN treaty obligations um, are largely met through the current medical marijuana state licensed regimes. These include things like having marijuana only for medical and scientific purposes, early only, having federal estimates of the quantities of the substance to be consumed, used, and stocked, production quotas, having a licensing system, having robust record keeping, prescription obligations, and to have the federal government monopolize the wholesale trade. These are items that can be accomplished with Schedule 3 and in reliance heavily on the existing state license systems. And that's the conclusion that Acting Attorney General Blanche came to in ordering the immediate rescheduling of medical marijuana.
So what does that sort of deference to state frameworks look like in practice?
So it's really remarkable, and I can't overstate, kind of how unexpected this was. I think when when the industry first became aware in 2023, August of 2023, when the Health and Human Services memorandum and recommendation that marijuana be rescheduled to Schedule 3, I think most folks assumed, okay, if marijuana gets rescheduled to Schedule 3, most of what these companies, these licensees will be doing probably still won't fully comport with federal law for a whole host of reasons. I don't think anybody really saw what's been proposed here, in that the way that this has been set up, there is now an expedited licensing process for DEA registration for all state medical marijuana licensees to apply for DEA registration with proof of their state licensure, and their DEA registration shall be issued, meaning it's mandatory. And they will be, these companies that have state medical licenses will have DEA registration that allows them to perform activities that are coextensive with their state license, meaning basically the DEA is going to federally legalize to some extent their business operations. And so the scope of the rescheduling taking that amount of breadth, I didn't have that on my tarot card when we first started talking about rescheduling. I think most of us were thinking, okay, rescheduling gets 280E off the table, but this is significantly further than that.
Let's see. So what other kind of recording and reporting requirements are going to be there? I mean, is this really just a matter of I tell the DEA that I'm a state licensed medical facility and now I just operate under the state's framework and that's it?
Well, I think we're still kind of in the early days here as far as what we're going to expect from DEA in terms of additional reporting requirements. But DEA, the way that this order is written and the way that the administrative rules are drafted here largely suggests that the state license process is going to satisfy all of the treaty obligations from a record keeping and recording requirements. So the only kind of significant change for these state medical licensees is that the federal government has to be involved in the wholesale system to satisfy treaty obligations. So manufacturers of marijuana will now have to establish a nominal purchase and sale price for their product. They will, quote unquote, sell their product to the federal government and then immediately buy it back and will pay the federal government some sort of to be defined administrative fee for handling that transaction. That really purports to be about the total extent of the changes at this point in time. Certainly, we would expect DEA will have the authority to request additional record keeping, but that's, as we sit here right now, it kind of looks all like upside as I'm sitting here.
Is that administrative fee though? Is that maybe a backdoor way for there to be a federal tax on marijuana?
That is not what the order suggests. It really just suggests it'll be some sort of modest fee to cover the costs of DEA having to perform this function. So I don't get the sense that this is a revenue generating activity. It seems like it's a cost covering activity.
Okay. How about prescriptions? I mean, if Schedule 3 substances are required to be prescribed by a doctor, That's certainly not what's mandated by some of the, state licensure frameworks.
Again, this is where I don't think anybody had this on their bingo card, but the way the order is drafted, the state certifications for medical marijuana are acceptable in lieu of getting a prescription from a physician or a pharmacist, as long as they contain the name and address of the doctor, the date they were signed, and identify the name of the doctor. And I can speak for Michigan personally, but I believe all states that have a medical marijuana program, their state certification that you would get from a physician to recommend medical marijuana is almost certainly going to comply with those requirements in all respects.
Well, I certainly remember years ago my 5-minute medical appointments, and I'm sure there are some of those doctors who were heavily engaged in writing referrals that will be thrilled by this because they're back in business.
Yep. They're all those clinics I think are about to reopen. They'll have a new customer base for sure.
Well, I think it's probably time now to talk a little bit about what the order doesn't do before we dive into some of the more interesting sort of nuances and questions that it presents. Yeah, the big thing the order doesn't do is adult use. Adult use or recreational use, however you want to term it, is not authorized through this order. This is purely treating marijuana as medicine. But at the same time, the Attorney General also reset the rescheduling hearing that had been triggered before during that Biden process you mentioned, and set it on a really accelerated schedule. It's going to be sort of the end of June into early July, and it's only a week or two in maximum length. So we're going to see something on adult use fairly soon. We'll talk about a little bit about what that might look like here in a few minutes. And then also the order doesn't allow synthetically derived substances. And it specifically identifies Delta 10 as one such substance. So I think you're still going to see that delineation that the feds have wanted to draw between so-called hemp-derived or synthetically derived substances and those that are produced through a natural process.
That's a good point, Lance. And to take a step back too on the administrative hearing process, folks may recall during the Biden administration, the rescheduling rulemaking process got completely bogged down with legal challenges. There was allegations that the then DEA administrator was not in favor of rescheduling, and that they had stacked the administrative hearing such that it would be heavily influenced against rescheduling. And so that process became bogged down. And so it's important to note this new administrative hearing process is starting from scratch. It's not resuming that old process. It's going to be starting from scratch. They're relying on the notice of proposed rulemaking that was put forward in 2024, but they are starting that process from scratch with a blank slate when it comes to who will offer testimony and who will be permitted to testify. And the press release from the acting attorney general is pretty unequivocal that they intend to move that hearing process forward quickly and efficiently, and to get this thing done. And so I don't recall there being that same level of enthusiasm the last go around. So nothing's ever a done deal, but this thing sure seems to be moving forward with speed now.
Yeah, I mean, I do think over the years we have seen, over the recent years, we've seen federal elected officials want to get out there and say they're doing something, but then they don't actually task their administration with moving forward. This is clearly a new day, and it's one that's very, very welcome after, almost 100 years back to the Marijuana Tax Act of the federal government firmly placing its thumb on the opposite side of the scale and disregarding all of the medicinal uses. So it's nice to see some balance brought back to that and some reasoned thinking. The other issue that we've talked about before, because we covered it on our podcast, back when President Trump's executive order went into effect, is 280E. The the revenue code, Internal Revenue Code's provision that prohibits businesses engaged in the trafficking of Schedule 1 or Schedule 2 substances from taking any business deductions. You know, that tax provision is no longer going to be applicable to marijuana activity under the new Schedule 3 framework. And importantly, too, I found it very interesting that the Attorney General not only made that point, even though it's not really DOJ's statute that's being administered, it's the Internal Revenue Code, but the AG made that point and also encouraged Treasury to consider retroactive application when it comes to 280E relief. So let's talk about that a little bit, because I think that's going to be top of mind for a lot of our listeners. Um, you know, what has Treasury said about that, and what should we be thinking about when it comes to 280E?
So, right, remember, still, we're only talking about medical. Adult use and 280E relief will come whenever this administrative hearing process plays out. But for right now, Treasury's put out a press release indicating that they're working on formal guidance consistent with last week's rescheduling order, and it's their position that 280E relief would occur in the year of the effective date of the order. So, for folks that are on a calendar year tax year, if they have medical marijuana business activities, it'll be for their 2026 tax year when they file their 2026 taxes that they'll see 280E relief. Certainly, the fact that Acting Attorney General Blanche went out of his way to suggest that the Treasury should consider retroactive application. I suspect you'll get some folks that are aggressive and try to pursue retroactive refunds of 280E taxes paid, and we'll see how those play out in tax court and in other forums. But for right now, Treasury's position is 2026 tax year would be the first year that these licensees would see 280E relief on the medical side.
Well, I mean, that's a great point with respect to DOJ and litigation with ongoing challenges, because I think, well, as I mentioned, I mean, Treasury administers the Internal Revenue Code, but it's DOJ that's out there defending these challenges and handling these cases right now concerning the application of 280E. And I think we can safely say this administration has not been shy about having the Department of Justice do a complete 180 on positions it's taken in court already. So it'd be interesting to see what happens there. And I think it'd be also be interesting to see how any kind of retroactive relief would differentiate between companies that complied with 280E and those that challenged 280E or simply ignored it.
Yeah, these are all questions that had will take time to resolve. I know as recently as maybe last year or the year before, Treasury had put out clear guidance that they disagreed with the notion that 280E was inapplicable and that folks could just claim refunds or file amended returns for it. And so, we could have an about face, but so far right now, the early kind of messagings out of Treasury are that this 280E change will be prospective as opposed to retroactive.
Well, and certainly to the extent they're apportioning that relief between medical cannabis and adult use cannabis, I mean, I think for those companies that are operating in medical only states, there's complete relief. But for those who are in dual license states like Michigan, where you've got adult use and medical licenses, obviously the vast majority of the business is taking place in the adult use framework. So be interesting to see what comes out of the hearings here on rescheduling writ large. And I think also what happens in those states where you can transfer marijuana from medical to adult use status. How do you see that playing out?
So we're still very early, right? We're 4 days removed from this news. So my hope is if we get broad rescheduling to Schedule 3 still before the end of this year and for the 2026 tax year, then it would be significantly less complicated for dual licensees, because then 280E just kind of doesn't matter whether you're medical only or you're dual licensed. Um, so that's the fingers crossed. Uh, everybody's hoping for outcome, I think. As far as how you start looking at things from a practical perspective, if you're in a dual license state, I think there's going to be a lot of folks that are, maybe on the manufacturing side of the supply chain, cultivators and processors, that are going to want to give some serious thought as to whether or not they want to transition most or all of their business to a medical license to avail themselves of effectively being in a spot where they have a DEA registration and they're not violating the Controlled Substances Act. And so that will be interesting, and how that plays out with those products moving down the supply chain and then potentially being transferred from medical to adult use by a subsequent licensee. These are all questions that are just kind of open-ended at this particular point in time. But I don't know, once the product has left your custody and control, and you did everything within the scope of your medical license, how the position could be taken that you somehow were acting contrary to the scope of your state medical license, or contrary to your DEA registration, being that your DEA registration authorizes you to do exactly what your state medical license authorizes you to do. So these will be very interesting questions as we're sitting here early. I think these are all the right questions to be asking, and I know these are the ones that everybody in this space is going to be thinking about very carefully.
Yeah, I don't know how many answers there are right now. I mean, you think about the fact that we've seen, everybody who can sort of gravitate to vertical integration so that they can, have viable tax strategies when it comes to dealing with 280E. Now, maybe some of that starts falling apart. And I don't know at this point. We're going to have to see. Will some state licensees choose not to register with DEA? Will some states maybe require DEA registration? I mean, especially in medical only states. And what kind of other laws, state laws, may change or require changes? I mean, Michigan, for example, I believe still has a law on the books that if marijuana is rescheduled, then it becomes a product to move through pharmaceutical channels. Certainly, the MMFLA post dated that the statute in Michigan that regulates the medical marijuana industry, but yeah, is that an amendment by implication? There are going to be some interesting constitutional questions there. And I also wonder if, all of a sudden, hey, maybe these, at least in Michigan, we've got provisioning centers is the preferred term and the legal term for a medical retail outlet, because Michigan law doesn't allow a cannabis facility to call itself a dispensary. You have to be dispensing a medical product. Well, hey, maybe now all of our dispensaries really can call themselves dispensaries.
Yeah. Yeah. And Lance, I'm wondering how you're thinking about, moving forward to adult use. I'm cautiously pessimistic that we'll see the same level of breadth with an adult use rescheduling order that would allow DEA registration. What are your thoughts there on what that's going to look like?
Well, I do worry a little bit about the method the Attorney General chose to use last week. I mean, I think it was a brilliant masterstroke in terms of getting outside of the standard Administrative Procedure Act, notice and comment rulemaking, and moving forward quickly. But at the same time, so much of that order is spent discussing compliance with the single conventions requirements for marijuana, and really predicated on a medical use that I'm not sure how well that translates for adult use. I mean, how do you meet the medical and scientific purposes only requirement? Production quotas, medical prescriptions of some form. I don't know that all of that easily moves over to the adult use framework.
Yeah, I don't see how it can. Right, on the medical side, you have a medical purpose that you have a physician's recommendation for. On the adult use side, the synonym for adult use is recreational. So I don't know that will square itself to get the kind of full compliance with the CSA on the adult use side, like apparently we can have on the medical side. So I think there will still be a tension point between medical and adult use, assuming broader rescheduling occurs later this year, and it may still cause some folks to make the decision, hey, it makes sense for us to be a medical only licensed business, because we are now not just state legal. We could take the position that we're federally legal too.
Yeah, certainly. I tend to agree. I mean, it's going to be a challenge to sort of shift that paradigm over for adult use as well. I think, the other item that sort of stood out to me in terms of how the new federal rules, because they are new rules that are now in effect, how those intersect with the single convention, is that where the federal rule directs DEA to largely borrow from and rely upon state licensing and regulatory frameworks, the order does repeatedly note one of the single convention requirements, that there be production quotas, both at a manufacturer level and nationwide. And I found it sort of interesting that the executive order, or the order rather, does not defer to state regulation when it comes to that item. So that's another issue. We're going to have to see how that plays out, and whether that becomes a basis for some folks not to get their registration, or perhaps some states that really have unconstrained supply, as it were.
Yeah, Lance, do you think this order will stand up in court? I know there's whenever you talk marijuana policy, litigation always follows. What have you heard on that front?
Well, I think look, smart approaches to marijuana. The anti cannabis group announced immediately that it intends to sue. So I think there will be challenges here. There will certainly be, some questions as to standing, some questions as to legal theories. I do think the administration's determination that treaty obligations are being met is probably an unreviewable political question. It's always sort of the imperative of the executive branch to decide how treaty obligations are met. But I do think there will be some questions about whether the reliance on state frameworks really does satisfy the requirements of federal statutes. I mean, I think of, Oklahoma's early on sort of wide open licensing with thousands of licensees, thousands of licenses granted in 3 weeks. I think that's questionable, but it's probably an arbitrary and capricious standard. So hard to bring a challenge there. Where I really see the biggest challenge arising is a challenge to the scope of the Attorney General's authority under the CSA. So the provision that he relied upon, again, is one that says that, if controlling a substance is required by the treaty obligations that were in effect in 1970, the single convention, then, and I quote, the Attorney General shall issue an order controlling such drug under the schedule he deems most appropriate to carry out such obligations. And, that method is not subject to APA rulemaking per the CSA itself, but it also certainly appears intended to allow for the scheduling of a substance that becomes a concern more quickly. So really the ability to put something on a schedule that isn't, it's not clear to me that it includes the ability to reschedule downward. And I think the controlling such drug under the schedule he deems most appropriate raises a real question as to whether the AG's authority is limited to placing the drug on a chosen schedule, or if the AG really can go out and create all kinds of specific new rules for a specific substance, which is what took place, with marijuana. We have all of these new rules now that are specific only to that drug, not specific to a particular schedule.
Yeah, that's an interesting note, and if folks haven't read the order, we'll make sure to have a link to it in the description of this podcast episode. But if you read through the order, Acting Attorney General Blanche goes I think through a good amount of effort to detail his position that there are multiple different schedules that marijuana could potentially fit into, and he indicates, I'm going to use my discretion to pick Schedule 3 because it best harmonizes with what sound policy is. And he says, I don't have to consider the HHS recommendation, but I find it persuasive. So these are all interesting things. It's going to be a fascinating approach to play out, and presumably you'd expect Sam, Smart Approaches to Marijuana, is going to try some preliminary injunctive relief, and that will kind of rule the day here, right? Whether or not the rule and the order gets gets enjoined by a court, or whether or not it gets to go forward. And like so many things, once the cat's out of the bag, it's kind of hard to put it back in.
Well, I think, and that's certainly been the story of the industry. The toothpaste is out of the tube here, regardless of whether Sam wants to acknowledge it or not. We're not going back to the 1980s, the 1970s, or the 1930s here. I think we're only moving in one direction. Certainly from a consumer standpoint, so many Americans rely on marijuana for health purposes. So many use it for health benefits, even if it's not a particular medical need. And I think, from a consumer standpoint, are there things we haven't talked about yet that consumers ought to be thinking about?
Yeah, I mean, that's a good point. So obviously, if these businesses are now fully federally legal, a lot of kind of what I would call workarounds, become unnecessary. For example, right? Credit card merchant services should open up for medical licensees that have their DEA registration. Those businesses are no longer violating the Controlled Substances Act. There's questions about whether or not your personal health insurance or an HSA account could be used to purchase medical marijuana, something that fundamentally, if anybody said maybe 15 years ago, you would have been laughed out of the room as being ridiculous. These things may overnight just become a real reality. There could be labor and employment considerations for folks that have medical marijuana. And so at that point, you're using a controlled substance that effectively is now more or less a prescription medication. Could you be terminated for using what is now a federally legal medication as part of a workplace drug policy? These are questions that are going to get litigated. They're going to work their way through the system, and are really going to fundamentally change, I think, how some people interact with regulated cannabis.
Yeah. Well, it is definitely going to be a fascinating ride here. It has been for the last decade or so in this space, certainly, and we're going to continue to see rapid change.
Lance, what are you thinking as far as other things that what other doors do you think are open for state medical licensees that go out and get their DEA registration?
Well, again, I think it probably turns on whether they're in dual license states or not. I mean, I think for companies that continue to hold an adult use license, they'll still face some barriers. But, companies, if you're medical only now, I mean, think about bankruptcy. We've had, these rash of receiverships here in Michigan and California, in some of Colorado, and those states where there's not a cap on production licenses. We've seen oversupply, and we've seen businesses failing, and they can't go into bankruptcy court. So everything gets worked out through a state court process that's not usually as neat. That may change. That should change. Bankruptcy relief should be immediately available, I would think, for medical licensees that operate only under DEA registration. Because as you pointed out earlier, those appear now to be fully federally legal businesses. So, I think that banking and insurance opportunities may open as well. Credit card merchant services, as you mentioned. I mean, those are private actors that are going to have to make those decisions, though. So that may come, certainly more slowly. It's not going to be immediate, but yeah, I think there's some real short-term impacts here. Even, think about SBA loans. We went through all this fight not that long ago about medical marijuana or just cannabis businesses in general making use of some of the loans and funding during COVID. All of a sudden, something like that happens again, and those folks would appear to be perfectly fine to participate in the same benefits and opportunities as other legal businesses.
That's an excellent point. It's in this whole change here has had my brain spinning over the last couple days of, whether we are going to see folks fundamentally rethink how the supply chain is licensed. I think certainly on the customer facing, the retail side of the business, I think in Michigan, 99.8% of all sales are on the adult use side. So I'm not going to be naive here and think, oh, well, we're going to have a significant change in consumer habits at the retail side of the transaction. But for dual license states like Michigan, the existing administrative rules allow product to be transferred from medical to adult use. And so, my head's kind of spinning with it, will it make sense for growers or processors on the supply chain to restructure and be medical only businesses so that they can avail themselves of the full benefits that come with being fully federally legal and adult use businesses at the retail side, have to, they'll have some issues still to navigate with the conflict between state and federal law. But for some of these businesses, I wonder whether or not we're going to see some of that fundamental kind of sea change to have folks go back to medical only.
Yeah, well, I would certainly hope to see the Michigan industry use this to try to get some of the Michigan customers to move back into that medical framework. I mean, we don't need to shift product to adult use at the end. People need to go get their cards again. And that's going to be a cost savings to the benefit of the entire industry because, hey, guess what? Michigan's new wholesale excise tax no longer applies. It doesn't apply to products sold under the medical framework. Does the legislature here have a willingness to blatantly extend that tax hike to people using it for medical purposes? They might. I think we were all surprised with how they acted the end of last legislative year. But at the same time, this is maybe an opportunity for everybody to get a little bit of savings and claw some money back from the state.
Yeah. Not only the 24% wholesale tax, but the 10% excise tax on retail is only on the adult use side too. So the medical side has significantly fewer tax burdens. So it's going to be really interesting to see how things shake out in the days and weeks to come. And just before we started recording here, we were talking about back when the CRA promulgated, the Michigan Cannabis Regulatory Agency promulgated their most recent set of rules. They established a license type for an educational research license for colleges and universities, and nothing much had been done of that with that license because most colleges and universities get a significant amount of federal funding, and so they didn't want to be overtly breaking federal law by possessing marijuana. Now, boy, that concern seems to have gone out the window, and we may see a flurry of universities and research institutions now across the country get access to medical marijuana from the licensed market to start performing really a substantial amount of research in clinical and other settings. So that's really exciting news. I don't think I've seen too many people talking about.
No, you're right, and hopefully that can help put an end to this canard that marijuana hasn't been adequately studied. I think it's been studied and used for thousands of years, but the opportunity for more scientific research is something that should benefit everybody.
Absolutely. I know we're all watching closely on what's to come, and we hope you'll stay tuned with us. We'll certainly probably have a couple more follow-up episodes here as we get some more information and we kind of monitor how this thing is going to shake out. Lance, any closing thoughts?
Yes, give money to organizations that are going to get involved and oppose the inevitable litigation.
Good advice always. Good advice always.
Keep the normal guys happy.
Absolutely. Well, thanks so much for spending time with us today on behalf of A Higher Law. I'm John Frazier.
And I'm Lance Baldry. Thanks for listening.